We have a panel in front of us, and so we'll get started right away. Let me introduce the panel, which is Mr. Felton Howard, Mr. Jerry Needham, who is the Assistant Federal Defender from the District of Oregon, Ms. Jennifer Cleveland, Ms. Melinda Bell, Magistrate Judge John Acosta from the District of Oregon, and Mr. Matthew McHenry, who is a CJA panel attorney here in Oregon. And so we're going to get started. It is my understanding that, Mr. Needham, you're going to go ahead and I want to remind everybody we're going to have brief opening statements, and then the committee will be asking some questions. And so, Mr. Needham, my understanding is that you are going to begin the opening statement and then introduce your clients. Is that correct?
That is correct. Well, I appreciate the opportunity to address the committee, and just begin by letting everyone know my name is Jerry Needham. I've been a federal public defender here.
And can you get a little closer to the microphone? They're very direct.
Okay. I've been an assistant federal public defender here in the District of Oregon for the last 20 years. Prior to that, I was a criminal defense attorney with the Legal Aid Society in New York City. So I think I have a pretty good perspective on a busy, overworked, underfunded state system and the state of the art here in the District of Oregon. Before I introduce my client, Jennifer Cleveland, and Mr. Howard, I just wanted to give the committee a little overview of the approach that the Federal Defender's Office here in the District of Oregon takes with our cases. Our commitment is to the whole client approach. As the committee is probably aware, many of the individuals that come into federal court have a long array of social problems, from mental illness, drug and alcohol addiction, unemployment, housing problems. We attempt to address as best we can all these aspects of our clients' backgrounds. We are committed to the approach of that a stable client is better, obviously, for the client and the outcome of the criminal case, as well as the safety of the community and the long-range goal of rehabilitation. In the District of Oregon, the Federal Defender's Office typically are appointed pursuant to a duty assignment. Every day, an assistant federal public defender is assigned to represent individuals who are brought into court that day on a new arrest. In Ms. Cleveland's case, the government notified our office on a Friday afternoon that they were bringing in over 25 people on a Monday morning. They had a large investigation, and over 25 individuals were going to be arrested over the weekend. They didn't give us the names of the individuals, but they advised us, so that we contacted the pretrial services office and made arrangements with the marshals. They brought in 25 individuals at 7 o'clock in the morning. We had over half a dozen attorneys in the marshal's lockup. Pretrial services had most of their staff there. We were able to meet with 25 individuals and go through their charging instruments with them, as well as have most of them interviewed by pretrial services. That is typically how we get appointed. So that was just an example of the 3-4 different agencies in the District of Oregon working together so that individuals, when they arrived in the courthouse, would get representation and have an orderly process through their initial appearance and arraignment. Ms. Cleveland was interviewed by pretrial services. We made an appearance before the federal magistrate. She was ordered released. Pretrial believed that she was at risk to reoffend into drug use. They recommended that she be assessed. Due to Ms. Cleveland's past drug use, she was at risk to reoffend, so it was recommended that she go into a pretrial residential treatment. In the District of Oregon, there are 2 providers that have contracts with pretrial services. At that point in time, there was no beds available. Ms. Cleveland was able to obtain inpatient treatment. She went into a facility in Vancouver. This was not contracted with the government. This was private source funding. She went through a 6-month inpatient treatment program. She went back to school. She went to community college. She went undergone counseling. She was able to obtain volunteer employment, and then part-time employment, then full-time employment. While this process was going on, my investigator assigned to the case, Susan Moffett, gathered background materials. It came to light that Ms. Cleveland had a number of traumas that were inflicted upon her as a young child, and I briefly mentioned some of that in my submission to the committee, and I won't go through that. We were able to gather evidence. We were able to interview individuals about her background. My office then permitted me to hire a forensic psychologist. The forensic psychologist met with Ms. Cleveland, reviewed the materials that we had gathered, prepared an evaluation, was able to put together a picture of why the trauma and the events that occurred when Ms. Cleveland was a young minor had inflicted upon her, and why she had turned to illegal drug use. She had 2 prior felony convictions that scored under the advisory guidelines, and she was indicted as essentially a career offender. Her advisory guidelines were 151 months to 188 months, assuming a plea of guilty to the most serious charge. We presented our mitigation materials to the United States Prosecutor's Office. They were very receptive. They reviewed our materials and made a recommendation of a variance from 151 months to 92 months. Our investigation continued in regard to mitigation. There was unfortunately overwhelming proof against Ms. Cleveland. We continued our negotiation with the government, and as we gathered further records, the government ultimately came to sentencing and recommended a 70-month term of imprisonment. Because we had been able to obtain this information about Ms. Cleveland's background, as well as a forensic psychologist and other witnesses, we were able to convince the district court to depart downward to a term of probation. Judge Brown imposed a sentence of 5 years probation, which included 9 months of home confinement, well, not home confinement, at a reentry center. The reason that Ms. Cleveland is here is to tell the committee why all these resources were available to her and what impact they had on her and the direction of her case. Judge Brown commented that she had never gone to this extraordinary lengths to make a departure of some 24 levels under the advisory guidelines. Ms. Cleveland has now been clean and sober for 2 years. There's been no reoccurrence of any type of criminal conduct. She is prepared to file her first tax return this year, and is expecting a refund for the work she's done last year. So Ms. Cleveland has a brief statement that she would like to give to the committee, and when she's done, I'll introduce Mr. Howard. What's that? No, go ahead.
For me. Hi, I'm Jennifer Cleveland. I'm 38 years old. I grew up in California, Florida, Portland most of my life. I had a pretty horrific childhood. I started using drugs at the age of 15. In and out of, I went to prison a couple times, in and out of jail. I remember right before I got arrested, I remember waking up at 36 years old in a attic in somebody else's house, looking around at all my possessions in boxes, wondering, is this what my life's come to? 36 years old, wow, all my stuff's in boxes, this is great. So when I got arrested on this case, I realized I needed to make a change, and I never had the help to make that change. And So when I was released on pretrial, I was released to my mother. We bashed heads, so it wasn't great. I had to go back to where I first was arrested, and so I needed to make a choice because I didn't want to go back to using drugs. So I found a faith-based treatment center. I got myself in there. I started school. I started volunteer work, then I started school, then I started work, and I kept volunteering there. And Jerry and Susan and Miss Martin, they were always checking up on me, seeing how things were going. The evaluation with Miss Martin was it was very painful. I wouldn't want to ever have to do that again, but she helped me face some demons and realize some things. And so I could have fallen into some deep depression if it wasn't for them being there for me. They were there. I remember when we were in jail that a lot of the clients or a lot of people would say that we just felt like we were a number, that just hurry up and get us through the court and get us out of here. But with Jerry and Susan and everybody, we actually felt like they helped us. They were actually there to help us help ourselves so that I could actually do something with my life. And like he said, today where I'm at is I'm a responsible adult and I'm actually going to file my first taxes. So that's it.
Well, thank you. Mr. Howard was initially, and all throughout his criminal case, he was arrested by Steve Wax, who I understand testified this morning. Mr. Howard was indicted back in 2005 for the distribution of crack cocaine. And it was a 5-year mandatory minimum based on the amount that was in the indictment. Mr. Howard was released on pretrial conditions. He had some difficulty on pretrial release, and he was taken back into custody. He was given a second opportunity, did much better that second time. He met with Mr. Wax. I understand he was evaluated at some point in time. It was his first time to actually sit down with a psychologist and face some of his demons. Mr. Wax was able to negotiate a plea agreement where the government waived the mandatory minimum. He was ultimately sentenced to an 18-month term of imprisonment. Shortly thereafter, the United States Sentencing Commission reduced the guidelines for crack cocaine. Mr. Wax was again appointed to represent him due to a 2-level reduction in his offense level. He was ultimately sentenced to a period of time served. When he was released, he was admitted to the reentry court or the drug court here in the District of Oregon. Judge Redden was at that time running the drug court. He performed very well, got a reduction in his supervised release term, and was released from supervised release early. Now, Mr. Howard is 5 or 6 years away from supervised release. He's giving back to the community, and he is a program manager at the Reentry Center here in Portland at Mercy Corps, and I'm very happy to introduce Mr. Howard.
Thank you. One of the things that got me here is when they said that Steve Wax kind of recommended me to come here, and I just made the joke that if Steve asked, I'd do anything Steve asked me to do as long as it was legal. You know, that's how good he was with me. I was listening to this young lady right here tell about her that she woke up after 36 years and realized that she was in trouble and that she was a drug addict. And I just reflect on the fact that I had 36 years of bad behavior, you know. And I always tell all the young people that come into my office that, you know, you're getting it now, you need to keep it. You know, I wish somebody would have gave it to me when I was 36. And I think if I would have met somebody like Steve back at that particular time, I might have straightened up. Unlike her, I didn't have any real trauma in my life. My parents were great. I had a great childhood up until the time I was 16, and I got arrested for the first time for smoking weed on the beach in Tillamook County. Spent 3 days in jail. That's the first time I was ever in jail. And I had a series of arrests, just booking releases for the next 36 years. I actually got arrested for the first time and spent some time, actually went upstairs in the Justice Center for the first time when I was 52 years old. I never spent the night in jail before. I just, a lot of book and release. And I remember the judge in the courtroom that I had to go to after the bad behavior you were talking about, where I wasn't doing well on pretrial. I can't remember the judge I was before, but he told me, he says, Mr. Howard, you've been doing a whole lot of book and release. He says, this is the United States of America and we don't play. Exactly what he said. And he gave me a choice. He told me that I could spend the rest of this time I wanted in jail, wait until my sentencing, or they would put me into a treatment center. And so I went into Willamette Family Treatment Center, and I think that's when I finally got it. It was the worst experience I've had in my life. But I got through it, and I think that, that's what helped change. Now, the thing I want to say about Steve, and you guys in this panel is here to kind of like look at how public defenders work. One thing I will say about Steve that was different from everything, I had lawyers before in the county system. And it's a little bit different with the county system. I know now because of the work I'm doing is there's a lot of, their caseloads are just like huge. One of the things that I noticed about Steve was once I got I did 17 days in Inverness, which was the first time I'd ever been locked up. And when I went to court after coming out of there, that's when I met Steve. And Steve told me right away, he goes, here's the guidelines. He says, I'm gonna be your lawyer. He says, don't lie to me. He says, take my suggestions and we'll get along fine. And Steve was one of those ones that would call me. I never got any calls from my other lawyers. He called, he wanted to see how I was doing. He called the treatment center to see how I was doing. And when I got out, he sat down and brought me up to his office and opened up the big book, is what he called it, and showed me exactly what I was looking at, which basically had my heart doing like this, And he said, but we can get through it. He told me to put in some work, which I did a lot of work. I did some cognitive things. I finished the treatment center and all that. And I went before Judge Anna Brown, and he represented me there. And Ms. Brown, I was thinking myself that I may get probation and not have to go to jail, which, that's wishful thinking. I should have known that my sentencing date was 9/11/2006, so that wasn't a good omen to begin with. And she sentenced me to 18 months. But what she did tell me is that the work that I put in, that she would recommend if I got out of prison, I did well for a year, that she would recommend early release from probation. I did a year and a half on 4 years worth of probation, and they let me go. They released me from the probation. One of the things, last thing, I don't want to take a lot of time, but I want to let you know how deep Steve worked for me. I had an issue that happened in Sheridan. I was in Sheridan prison, and I was at the detention center, and one of the counselors there was kind of like stepping on my neck a little bit. I was supposed to be there for 8 weeks, and I was there for 4 months. And this was when they had 21-hour lockdown there. You only got out for 3 hours. So I called Steve and I asked him, I said, hey man, I'm supposed to be in here. I was only supposed to be in here for 8 weeks. It's going on 5 months. And so he said, oh, don't worry about it. He says, I'll take care of it. I said, hey man, be careful because these people hold a grudge. Don't get me in trouble. And he says, oh, I won't. Don't worry about it. I won't do anything. And like 2 days later, I got called up to into the counselor's office. And she said, oh, we found your paperwork. It was in Texas. And so I was released to the federal corrections, actually the FCI at Sheridan about probably 4 or 5 days after that. And I know that was Steve that called in and wanted to know why was this guy still here. And Steve is also, I think he was one of the people, if I'm correct now, that helped spearhead the crack laws. And out of his office, he worked hard on that. And some of the lawyers from the Federal Public Defender's Office here came and visited us in Sheridan and let us know what was going on with that, which I thought was really thoughtful because we had no idea what they were even doing. And they gathered a bunch of us up together in the prison and explained about the crack laws. When I was released from Sheridan, I walked out of Sheridan December the 10th, 2007. Steve was on the phone as I was pulling out of the parking lot telling them they had to let me go. And so, for me, it was like somebody who was actually paying attention to a human being rather than, you know, I really felt like he was going to bat for me. And the last thing I'd like to say is that yesterday was February the 2nd. That was the first time, 10 years ago, February 2nd was when I met Steve. And that's 10 years that I haven't had any drug use, and 10 years that I didn't have any criminality. That's my anniversary date. Thank you.
Congratulations. Judge Acosta.
Good afternoon. Thank you very much for this opportunity. I won't repeat what I said in my letter submission to the committee. What I'd like to do is expand a little bit on some of the origins of this district's court-assisted pretrial supervision program. I came to the bench in March of 2008 after 25 years in civil practice. I had no criminal law experience except some classes in law school and a semester of a clinic program that allowed me to participate in misdemeanor trials. That was the sole sum total of my experience. And I think because of the type of law I practiced in the large firms I practiced it in, I probably came to the bench with some misconceptions about who criminal defendants actually were. When you start to read the stories that cause them to be in the system, it changes your view, at least in my experience, quite quickly. You realize that the people who come to court in this system are not, they're not born bad people, but they've been born into bad circumstances by and large, or they've had some unfortunate circumstances along the way, or no one's taken an interest in them to show them the ways to be successful as individuals. The very first defendant in which I suppose, developed the CAPS concept was back in 2009. Before there was a CAPS program, I mentioned that in my letter. I want to explain a little bit about that particular case. He had a criminal history. It was a gun charge with drugs. The police went into his apartment unannounced on a warrant and picked him up. And it was a very close call for a release decision. I remember talking to the pretrial services officer in my office before calendar that day. We have criminal calendar every day at 1:30 here, Monday through Friday, and it was my duty month. And he was not recommending release. And I said, because it was a very close call on the charges and the evidence, and I said, would it make a difference if I met with him after I released him, maybe once a week or so? And he looked at me like, I guess he had never seen anything like me, because I suppose no one had ever suggested that to him before. We did that. One of the things that impressed me about this particular individual is when he appeared before me for his initial appearance, there were people there for him. His mother was there. He had an uncle. He had others. He had a community behind him. And it was a close call, and I wasn't sure I was doing the right thing, but I released him on conditions, and we started to meet in court once every week. And the approach I took, which is the approach that I ultimately adopted for most all of my CAPS defendants, is that very first meeting and at the several meetings that followed, I gave him homework. The first thing I asked him to do is to write about something that was very important to him. What did he want to do with his life? What did he want to do on pretrial release? What did he want to do after he was finished with this case? And I did that for two reasons. Sometimes it seemed to me no one's ever asked the people who are on the other side of this table what they want to do. Where do they see themselves? How do they think about their future? The other thing I wanted is when he wasn't before me in court, when he wasn't in his lawyer's office, when he wasn't meeting with his pretrial services officer, I wanted him to be thinking about me. I wanted him to be thinking about the things I'd asked him to do and the next meeting with me, and perhaps that would motivate him to at least provide additional incentive to comply with his release conditions. That's how we started. I ended up meeting with him for probably an 8 to 10 month period between the time I first saw him at initial appearance and the time of his sentencing. He did incredible work, and he did incredible work after 2 or 3 unforeseen, unfortunate developments in his life that would have thrown anyone else back into whatever habits they had developed, which had gotten them involved in the system in the first place. But he stayed with it, and he put 110% effort into complying with his release conditions, employment, school, meeting his treatment program requirements. At the sentencing hearing, which I attended, he had done so well that the assistant U.S. attorney assigned to the case was defending to the sentencing judge his recommendation for a below guidelines sentence for this individual. He was actually, I think it's fair to say, advocating for this individual and the sentencing recommendation the parties had reached. He served, he had an 18-month sentence. He served about a year of that. He went to a halfway house. He came out, and last year he got off paper. And I've seen him several times since, and his mother several times since. He has a young son. He has a very healthy relationship with the mother of his son. He's made some very good decisions. He has a business that he runs, and he is in a really, really good place. And he did the work. But the important takeaway from this is, because we took a different approach with him, he had support and encouragement from the system. He wasn't just, I think it was Ms. Cleveland who mentioned this just a few moments ago, he wasn't just treated as a number to be brought into court and then cycled out for the next case. And as Jerry mentioned, the approach in that case was really a whole client approach, and it served as the basis of the court's CAPS program. In that time since, I've had probably 2 to 3 dozen CAPS defendants. Now, one of the questions that some of you may have for me is, do they all succeed? No, they don't. They don't all succeed. That doesn't change my mind, however, that I think I can help everybody that I decide to take into the CAPS program. And as I sometimes say of my older daughter, sometimes wrong, but never uncertain. I always take them with the idea they're going to make it. They sometimes don't make it. But even when they don't make it, they are thankful for the opportunities they had, and they found something that in many instances they never had before. That is this. They found that they could do things, they could do good things, they could improve and change, and for some it just takes longer than others. I just want to mention briefly a couple of other CAPS defendants that I've worked with since that time. Another individual was before me on another felon in possession charge. He had a prior bank robbery conviction for which he had served 5 years in prison. He became an enforcer for an Aryan prison gang. He had the tattoos to prove it. He was a very difficult release decision for me, and I took him into the CAPS program, and he performed spectacularly. One of the things that helped him is he had a wife who kept him grounded. He had kids he cared about, and I used that, if you will, as leverage to help them stay focused on complying. He also had a skill. He was a welder, and during the time he was in the CAPS program with me, he became a journeyman welder, and he was so good, both at the technical requirements of his job as well as making sure the work got done on site, he became a foreman. He got straight probation from the sentencing judge, and that was absolutely deserved. He absolutely earned that. During that period of time, I think it's very important to point out, he had a drug addiction, and he had a drug addiction for many of the same reasons that Ms. Cleveland touched upon in her life. He wanted to get the tattoos removed from his neck. He refused prescription pain medication because he did not want to risk being tempted to basically go off of his sobriety. So he used Tylenol or Advil, but that was it. And if you know anything about tattoo removal, you know it's an extremely painful process, and these were on his neck. And he went through every treatment without prescription medication. That was how intensely dedicated he was to the success of his program. He's doing great now. He's been on probation for 2 years of his 5-year probationary sentence. and there have been no problems. The other person I want to mention was someone who was supposed to be here today who was not able to be here. And I mention him in particular because of all the CAPS defendants I've worked with, and as difficult as the circumstances have been that many of them come from, he started with the least, and he made the greatest progress because he started so far behind. He's an individual who's only a few years younger than I am. His whole life had been criminal history. I remember when the pretrial services officer came to talk to me about him, and here is a man who at the time was 52 years old. This was, what, 4 or 5 years ago, and there wasn't really anything to work with here. I mean, I couldn't really understand why we were going to take a chance on him because he had never been able to stay out of incarceration, either pretrial release or in any other way. But I put him in the CAPS program, and within a week he violated because he used. I brought him back into court, and I said, I'm going to temporarily revoke you and have you sit over the weekend to think about what you really want to do. In the meantime, we had him assessed. It turned into be a 2-week hiatus. I put him back in the CAPS program. He went out and he did great. He got straight probation from the sentencing judge, and he's been doing really well. I continue to meet with him, even though he's now on probation, because I suppose I became part of his community. So the other person is Melinda Bell, who's here to my right, your left. Ms. Bell is another one of the tremendous success stories that I think are the hallmark of the whole client approach. And I really like that, Jerry, so I'm going to start using it now.
Thank you.
Ms. Bell is another one of those close calls. When I first saw her, the pretrial services officer who worked with me on the very first CAPS defendant I ever had, the one I mentioned to you already, recommended putting her in the CAPS program, and I had serious doubts whether she would be able to perform well and succeed. But I released her, and from the very beginning, Melinda Bell performed spectacularly. She was motivated to succeed. She has children that served as an anchor for her success, and over time, she became more and more successful in achieving goals that she set for herself. One of the things that we all do it differently here in the district, those of us who do the CAPS program, and one of the things that I do, if someone's been with me for a long time and done well, is instead of court, which is a rather constrained environment, it's formal, it can be intimidating, I bring these defendants back into my chambers. We sit in my office where they're surrounded by my world, so they see what I am and what I'm about, my family pictures, and we talk about their family, and we talk about strategies to succeed and preventative strategies if you start feeling those things that maybe tempt you to go sideways and violate your conditions. And every step of the way, Ms. Bell showed tremendous judgment. She showed tremendous resolve, and she showed a tenacious persistence to succeed that was impressive. It was incredibly impressive. Melinda got straight probation, and last year, was it August?
August.
She got off paper early. And she'll tell you more about this. She's involved now in a local program that has been not only very beneficial to her, but very, very constructive for those that she now works with. So with that, Melinda Bell.
Hi. So I'd just like to say that I was involved in a drug conspiracy that had like 18 other defendants. My attorney was Bob Reed. I'd struggled in the beginning. I went to the halfway house. They put me in the halfway house. I was there for a couple weeks. Then they put me in Tri-Cities where my kids were. I really hadn't been in any trouble before I got a DUI. I spent the night in jail. Some assaults, stuff like that, but never really had been in this much trouble. And I really didn't understand how much trouble I was in until my attorney started breaking things down for me. Like, you're getting ready to go to jail for 10 years to prison. I'm like, for what? And he's like, for the crime you committed. And I'm like, whoa, whoa, whoa. So between him, Bob Reed, Tiffany, I can't remember her last name, but she was my private investigator. They took the time to investigate my life, my early childhood, and figure out why I was doing the things I was doing. I told them that, I had been smoking weed since I was 2 years old. My mom put beer in my bottle when I was a baby so I'd fall asleep. So all these things that I was used to doing was forced on me as a child, as an infant, basically. And that's the way I grew up, I came from a line of drug dealers, pimps. Nobody really there to stop me and show me, well, hey, you need to go this way. I did graduate high school because I had to get up and go to school every day. Once I moved in with my grandmother, she was more stable. But once she passed, I went back out there and did whatever I wanted to do. So once Bob Reed and Tiffany started getting into the basics of why I was doing what I was doing, I was able to see for myself that was not me. That was somebody that was created through my past. And when I got out of jail, when Judge Acosta let me out, he told me, he's like, this is your last chance. Nobody gets 4 strikes. So you better make this one work. So I said, okay. And when I was in jail, I found a flyer on a bookshelf for Women's Life Change Program, Union Gospel Mission. And that's the program I chose because it was faith-based. So I had to work that program for 4 months before sentencing came up. And it was hard work. 2 weeks into my program, I wanted to go back to jail. I was just like, this is hard. It's easier to stay in jail and do nothing. Get up for meals, get up for Medline, and sleep. But he's like, no. He's like, you haven't did anything wrong, so I can't put you back in jail. So I was like, okay. So I went back to the Union Gospel Mission and started working my program. And I met with him every week for like 4 months. And he did give homework every time we met on top of my treatment that I already had. So for 4 months that happened. Then it came up to sentencing. And when I got sentenced, I was sentenced ultimately to a year in the program. So that was a blessing. I got time served and to do a year in this program. So ultimately my prison sentence was waived and I did 16 months in a rehab, in a residential treatment facility, which was great. I graduated that, was able to get some of my children here in Portland area to live with me. Because I'm not from this area, I'm from Hermiston, Oregon. And that was one of the things that when he let me out, I told him I didn't want to go back home because it was too easy for me to access the things that I wanted to use drugs and to control my environment. So it was better for me to stay out here. So I did. And I still live here. I live in Beaverton at the Union Gospel Mission Women's Life Change Program, where we can have our children with us. Yeah, what else?
All the work you did to get your license back and work with for the Spokane twins.
Oh yeah. So I didn't have a driver's license when I first came out here. My credit was bad. I was able to pay off a lot of my bills. I was able to get my driver's license back. I ultimately signed up after I graduated the first part of the program to a internship called WOW, Women of Wisdom, where I learned all the aspects of the ministry field inside of that organization. It's a nonprofit. My last job there was case manager. So I was getting women out of jail and giving them the second opportunity that I was afforded to get a second chance at life and speaking into their life, speaking back. Unfortunately, none of the women that I got out of jail were able to make it. One of my clients that I had is doing 50 months right now, but that was of her own choice. But I was just happy to be able to give her that opportunity that I was afforded through what I've learned here with CAPS hearings and the training that I was getting at Union Gospel Mission. Also, I have a set of twins that are with their father, who's a level 3 sex offender in Spokane, Washington, and
Let me speak to that just briefly while Melinda thinks about what she wants to say next. One of the things that impressed me very much about Melinda's evolution in the CAPS program is her decision-making. One of the problems that we see on the criminal side of the court's business are people who just make bad decisions. They have poor judgment. They go at things the wrong way. Oftentimes it's because, unlike those of us sitting in this room who are lawyers and judges, they don't know how to navigate the everyday things that we do. They don't know how to get their license back. They don't know how to get their Social Security card. They don't know how to do fill in the blank that we all know how to do and can't remember when we didn't know how to do it. Melinda's twins were a tremendous source of stress and sadness and anxiousness for her. But she worked through the proper process, and she's still doing that. And I think that is an amazing thing, because she's had every reason to be angry and to be vindictive in ways that might have gotten her into trouble at any point in her pretrial or probation process. But she made good, deliberate decisions. Is it over yet? It's not. Is it still frustrating for her? It absolutely is. Is she still working through the system the right way with a lawyer in Spokane? Yes, she is. And I have no doubt, just like everything else she's achieved, she will be successful at that as well.
Yes, thank you. So, yeah, like Judge Acosta said, I do have a lawyer, and I'm looking to start family reunification counseling with them soon. I haven't seen them for 3 years. At first, I blame myself for losing them to their father, who has this level 3 sex offender status. But at once I stopped blaming myself for being an addict and doing the things that I'd done, I was able to look forward to see that I will get my kids back someday. This is only temporary. And that was something that Bob Reed always would tell me to keep me going. He'd be like, this is only temporary. You're not going to spend the rest of your life like this. This is just one glitch in time that you're going to have. So, cheer up. Everything's going to be okay. And with meeting with Judge Acosta, as far as my twins go, there was times I come in there and I did a lot of crying, let out some things that I felt, and he listened. So for me, having the CAPS hearings and having the federal attorney that I had in the pretrial services and the investigator, I had accountability. They became like a family to me, and they helped me. They didn't dictate what they wanted me to do. They came alongside me and walked through this justice system with me, because like I said, I didn't understand the significance of what I had done and how serious I was in deep trouble. I didn't really get it. And by them, taking a chance on me, it gave me the opportunity to turn, and now I'm doing things that I would have never thought I would have done ever in life. I didn't think that I would be helping women that were doing the same thing I was doing, or even worse, or maybe even less, but giving them the strength to, just to even go on another day, and tell them that the sober life is a good life, and there's better ways of living than just the way that we were living. And also I'm showing my children now that I am a good mom. Before I thought I was a good mom, and I wasn't a very good mom when I was on drugs. But now I am. I'm there for their basketball games. I'm there for their football games. I'm there for parent-teacher conferences. I'm there for them, period. I'm there in the home every night, every day. When my son gets off the school bus, I'm picking him up outside off the school bus, and that would have never happened in my drug addiction. He'd have to come in the house by himself. So it's just the things that I've learned from being assisted with all this extra help that I never knew before is what helped me. Thank you.
Right. And Mr. McHenry.
Thank you. I want to thank the committee for the work you're doing, and then also for course, the opportunity to speak before you. I'll give you a little bit of background on me. I'm a partner at a small law firm here in Portland. I started doing criminal defense work when I was a second-year law student, and our now federal defender, Lisa Hay, hired me as a law clerk with no criminal work experience in my background whatsoever. I haven't looked back since that time, and since I graduated law school in 2004, I've done nothing but defense work for the last 12 years. My partner and I do a mix of privately retained cases and CJA work. We do trial level work, we do appellate level work, we do post-conviction and habeas work. I also spent a short stint at a local county public defender office right here in Portland. So I think I also come before this committee with kind of a broader view of the criminal justice system and what works and what doesn't, and how our work on the CJA panel and through the FPD here compares to other aspects of the criminal justice system. I love this work. I get to help people facing the direst of circumstances and get to meet my clients, who are the most unique and complex and incredible people that I've ever had the pleasure of running into. And I get to work with these folks to find positive outcomes to situations that when they start and when they first meet me, it doesn't look like there's going to be anything positive that can happen. And of course, I've seen some horrible outcomes as well. But for the most part, the vast majority of my clients end up bettering lives, bettering their own life, and bettering the lives of others when it's all said and done. And what I want to talk about today is how I'm able to do that, how we're able to achieve those results. And that's, I don't do it alone. I need lots of help. I'm not an expert at everything related to a criminal defense case. I'm not an expert at everything related to a particular client's case. I keep hearing the whole client approach. Jerry mentioned it, Judge Acosta mentioned it. I'm not sure who in this district coined that phrase, but it's certainly a phrase that all of the federal defenders use and that all the CJA panel attorneys use. What we try to do here is look at a client, not just what they're charged with. I want to know the background of that client. I want to know that client's upbringing. I want to know the intimate details of that client's life. Everybody that finds themselves in this system facing a federal charge has particular motivating factors for why they found themselves here. It's something in their family history. It could be a particular psychological diagnosis that has thus far been untreated. It could be manipulation by others. But I need to know these things. I need to know if the allegations against them are true, and if they're not, I need to know how to let others know about that, judges and attorneys. And to accomplish these things, I have to have experts, good, qualified experts that cost money and that have experience doing this kind of work. I need my investigators, I need my psychologists, I need mitigation experts, I need discovery experts, I need drug and alcohol evaluators. I see the other side have what seems to be a bottomless pool of resources. The prosecution has an endless supply of investigators and forensic experts and investigatory tactics and tools at their disposal. And those are all used, for the most part, with the goal of convicting my client and usually sending my client to prison. And the defendants that I defend, most of which have their very freedom at stake, need to have these same resources to make this a fair system. I spoke, in the materials that I gave the committee, I spoke of several cases with outcomes that we achieved that benefited not just my client, but the community. Outcomes that simply could not have been possible without experts I hired. Psychological evaluations, similar to what we've heard before, that revealed some deep-seated origins for drug use or mental health afflictions that were undiagnosed or untreated up to that point. Investigations that illuminate the true reasons for a client doing something. And through the use of these experts and, frankly, the wonderful support of our judges in this district who are willing to fund these experts, and a U.S. Attorney's Office that's willing to listen to us. We don't always see eye to eye, but they are willing to listen to what we have to say and to give us the time that we need to present a full case, to present the whole client to them. Through that, we've been able to get the people the treatment they need and to get them back into the community, to get them back working, to get them supporting themselves, their families, both financially and emotionally. We keep them out of prison. As I'm sure the committee is aware, the Charles Colson Task Force just last week released its final recommendations on how to improve the federal correction system. And their first recommendation was embracing alternatives to incarceration. Because that's where the science and the data say we can save lives and we can save money. By spending money up front for these experts, we keep people out of prison. We keep them to shorter prison sentences that save money for the public in the long run and get these folks, not just saving them money in terms of the institutional costs and the incarceration costs, but getting them back into their community and being productive and working and being good citizens and employees. And the way that we do that in this district is with qualified experts in appropriate cases. And I also want to emphasize that we don't just automatically ask for money for experts in every single case. There are cases that come along that occasionally I don't use an expert. And I also want this committee to know that none of this is a rubber stamp in this district. I have had judges call me. I have had the Federal Defender Office call me and say, I understand you want this expert. You need to explain to me exactly why this money is going to be spent here and why it's worth it to do it in this case. And I do that through affidavits and declarations and conversations, but this is not a situation where we ask for experts and the money just comes. There's somebody at every level looking at these requests very closely and calling people out when they're not required and making sure that the money that is spent in an intelligent way. Now, at this point, I was going to introduce a former client of mine, a woman named Italia Porter, a remarkable young woman who is kind of a shining example, I think, of the success stories that we can see that are echoed by Ms. Bell and Ms. Cleveland and the other folks that I know this panel's heard from. Unfortunately, Italia couldn't be here today. She contacted me late last night and had a medical family emergency that is requiring her to be away today. She's very sorry about that. She very much wanted to be here. She sends her regrets, but she did want me to say some things about what she would have liked this panel to know. In 2014, she was indicted on multiple charges of sex trafficking of a minor as a 24-year-old young woman for involvement in transporting a 16-year-old across state lines for the purposes of sex. And the charges she faced carried 10-year mandatory minimums. Italia had never been in any kind of trouble before other than an arrest for prostitution in Nevada. That was her only criminal history of any kind. When I got the discovery in the case, we sat down and we looked at the reports and listened to the recordings, and it looked very, very bad for Ms. Porter on paper. It looked like not only that she was highly involved in this, but was probably the leader of this conspiracy. And her version of the events was frankly very difficult to believe. And that was that she had somehow been manipulated by a pimp in California that she'd never met face to face. And she was released on pretrial supervision. And with the help of Mike McFarland at Pretrial Services, she got a full-time job. She stayed clean and sober the entire time she was on pretrial release. And I was given the funding to hire psychologist Dr. Linda Grounds, who I believe testified in front of this committee earlier this morning. And through Dr. Grounds' work, we were able to establish that not only was Italia's version of what had occurred believable, but it was surely what had occurred. Dr. Grounds did a very extensive psychological evaluation that dug into Italia's entire background and history. It was a painful process for her. But in the end, it was very clear that because of what some of the traumatic experiences that she'd faced as a young woman, that her explanation for what occurred was absolutely the truth and absolutely believable. And we took that report and we presented it with some more mitigating information to the U.S. attorney that was handling the case here. And it was Hannah Horsley, and she saw the whole client and agreed to dismiss the charges against Italia with an agreement that she would engage the services of a couple organizations here in Portland that specialize in assisting women from exiting the sex industry. And she engaged with those organizations. This was, I think the dismissal came about 1.5 years ago. She has a job at U.S. Bank. She has a healthy relationship. She has health benefits. She's rekindled her relationship with her mother. And all of this happened with her making only one court appearance. She was arraigned, and everything else happened behind the scenes, saving significant amounts of resources in terms of time and dollars. And what she would like you to know today is that without Dr. Grounds and without the resources that were available to her, she'd be sitting in prison right now. And she is one of several clients and success stories that I could relate to this committee, and I've related some of them to this committee already in my comments, and I don't need to repeat those here unless there's some specific questions about them. But that's what we do here, and we couldn't do that without qualified experts that cost money, and without judges that support us, and without, frankly, a U.S. Attorney's Office that's willing to listen to us.
All right, we're going to begin the questioning, and Judge Fischer, will start with you.
Thank you all for being here, especially the three of you with such wonderful information to provide to us. It's really stirring. But we are tasked with making recommendations to improve this system. So I'd like to ask Mr. Needham and Judge Acosta and Mr. McHenry, how do we translate the things that you've told us into specific recommendations to improve the CJA? You've mentioned, we need judges who will understand and do these things, and we need U.S. attorneys who will do that. And obviously, we need to make sure that all of the criminal defense lawyers know about these things as well. Do you have any more concrete suggestions for recommendations that we could make either in the present structure or with some change to the structure of the CJA that would make sure that what you're doing here becomes more widespread and that people know that it works and how it improves the system? Mr. Needham.
Well, I think as Mr. Wax and Mr. Hilliard testified this morning, you can't really place a number on a cap for a case, just an arbitrary cap. You have to give the discretion to the attorney and the court to determine what type of resources must be involved to properly defend the case. I'm not sure. I think the CJA cap is $3,500. That may work for a very slim number of cases, but that's just not realistic in today's federal criminal defense world, when we need experts to help analyze drug amounts, to deal with large computers, large discovery matters that we receive from the government. It's just unrealistic to set an arbitrary cap. I think the attorneys and the court must be able to have the discretion to put the resources that are needed on an individual case. I just wanted to comment a little bit about the CAPS program. I don't want the committee to think that just because a criminal defendant gets accepted to the CAPS program and he successfully completes it, that the United States Attorney's Office rolls over and recommends probation, or that the court automatically gives someone probation. That's not the case. It's one factor that I believe all the judges take into consideration on the 3553A. But many clients complete the CAPS program and end up having to self-report to serve a long prison sentence. But when they are released, they know that they have resources, they have people in the court system that will listen to them for their concerns. So I think it not only assists the client and the court and the community on the front end, but also on the back end when they're released, and ultimately most of them become productive members of the community. I think that saves money and is also a factor for the safety of the community. So I think, but to answer your question, the parties on the ground must have the ability to decide what is appropriate in each and every case.
Thanks. Judge Acosta, do you have something to add?
I agree generally with the things Jerry has said. There's a difference between throwing money at a problem and using resources well to problem solve, and there's a difference there. You just can't give the Public Defender's Office or CJA panel attorneys a set amount of money to file motions to suppress and go through the procedural motions, literally and figuratively, that comprise a significant amount of a criminal case. The people who come before the court through the criminal justice system are damaged in many ways that those of us here are not. And those problems need to be addressed with more than just the next court appearance or showing up at the pretrial services office to give your random UA. And it has to be okay for people like Mr. McHenry and Mr. Needham to know that they can invoke the resources of the system in ways that are non-conventional, that are creative, and that can be effective for the particular person, and that's okay. And I want to say one other thing before you hear from Mr. McHenry. I was a partner in the largest law firm in Oregon, one of the largest in the western states, and I was an equity partner, and one of my responsibilities was to review bills. Now, I'm not going to tell you that in my private practice I buried the bodies. I can neither confirm nor deny that in billing statements, but I sure know how to read them. And I know when a billing statement is on the up and up, and I know when a billing statement is maybe a little vague conveniently, maybe not as specific as it should be, or things are being done that seem to sure take a lot of time, more than it needed. As judges, it's our responsibility to review those voucher requests and to make sure, as Mr. McHenry pointed out, that, look, if we have a problem, we need to call, and I've done that. But it needs to be okay, and there can't be fear of fallout, retribution, consequences. If someone like Mr. McHenry or Mr. Needham have an idea for their client in this case because of her situation that is maybe not a mainstream or conventional approach, but could work for that person, and that needs to be okay, and there needs to be enough room in the budget for them to be able to try that. And if it doesn't fail, it doesn't mean it wasn't a good idea, it means it didn't work for that person, and that has to be okay too.
Thank you. Mr. McHenry?
Yeah, what I would add to what Mr. Needham and Judge Acosta already said is that we have dedicated resources here in our federal defender office. Our CJA panel in particular is administered by, I think, 3, maybe 4 full-time employees within the federal defender office. And that is what works, because I can call anytime during regular business hours or shoot an email over there anytime during regular business hours, and I get a response from somebody within minutes about what kind of funding should I ask for in this case? What do you think is an acceptable hourly rate here? Is this going to work for this expert? What should I put in my declaration to support this? what did I do wrong in the last case? What should I do differently this time around when I'm asking for this particular funding? This is not a situation where I'm trying to call up an attorney at the federal defender who has a full caseload and might be able to get back to me and talk to me about these things at some point later in the week. I'm able to we have dedicated staff who are wonderful, who are able to respond to us and let us know the resources that are available. And that's the other thing. Sometimes I don't know what's available. I can call up my federal defender office, the CJA people here, and say, I need a particular expert on this very discrete issue, and I have no idea who to call. And I'll have a list of 4 names by the end of the day of people that are qualified, who will work at CJA rates, and are available to do the kind of work that we need. And I think that is critically important, that we have that full-time dedicated staff whose only role is to support the CJA panel.
Well, I'd like to ask Mr. Howard and Ms. Cleveland and Ms. Bell if you could describe for us just a couple of qualities that you think we should be looking for or recommending in the kinds of people that come to our public defender's office and the kinds of people we appoint as panel attorneys that you think would be able to do the things that you've experienced. What should we be looking for?
I think that first off, you have to have some compassion. I think that's the number one thing I would think that would happen. You know, it's just kind of hard. I've sat on a couple of hiring panels, like the county asked me to sit on a panel for them to hire probation officers. Okay, so it's kind of, you know, it's like a full circle type thing for me. But what they're looking for is a different way of working with folks nowadays. And I know that the foot on the neck doesn't work anymore. And so when you're talking about, I think, defense attorneys, I think that what you're looking for is somebody who is willing to put in the work, who's willing to look at a person as an individual. Because what happens is, even though I was 52 years old, I had 4 kids, I was a grown man, I had done a whole lot of, you know, I'd done a lot of living. I was still scared to death when I was sitting there. I was confused. I didn't know what was going on. And with Steve, I think what he did was he took it step by step. He just showed me, I mean, it was just like a 3rd grade education. You know, he's working with a 3rd grader. He just broke everything down to me so I could understand it. I think that's what you would be looking for if I'm thinking that that's the question you're asking me. It's just someone that is willing to put in the work. Like I said, I could call him at any time and he would answer the phone. If he didn't answer the phone, one of his assistants would answer the phone. And then next thing you know, an hour later, Steve would be calling me. And this is what you're looking for when you're looking for somebody to be representing you in a situation like that. You know, I did what I did, I accepted what I did, but it didn't stop me from wanting to get the help, to get up over that.
Thank you. Ms. Cleveland, do you have any additional?
I would agree with Mr. Howard, and I think we need somebody more like Jerry. Open-mindedness and understanding and willing to put his all in to actually help myself.
Okay. Is there a tough love aspect of this? Is hearing some of the lawyers who appear before me and they say, you know, I had to take my client and say, look, here's what the deal.
He told me, look, this is what you're facing. I mean, there was serious moments. He's like, he was completely upfront and honest with me. He's like, this is what you're facing, but I'm going to do my best to get you this. And so.
Ms. Bell, do you have any?
Yeah, I'd have to say honesty. I'd also have to say that trustworthy. As far as Bob Reed, he gave it to me straight with no chaser. You know, this is how it's going to be. This is what it is. This is what you're looking at. Like she said, I'm going to do my best to defend you, but it's not looking so good, you know. So, and be willing to go that extra mile to see what's behind that individual, you know, because he could have just took my case, read it, said, okay, you're gonna go do those 10 months, you know, those 10 years. So just being willing to figure out the individual as that person instead of adding, like I said, I was in a group of 19 other people, 18 other people in a conspiracy, and they broke it down to where I just had my own separate case outside of the conspiracy, and that's how I was sentenced. So taking the extra time to see me.
Great, thank you.
Catherine, Ms. Rowe?
Thank you. Good afternoon. Mr. McHenry, I'm going to start with you. I just have a few questions about the experts and what it's like to try and get an expert in this district. It sounds like you and the other attorneys have it, well, I won't say easy, but it's certainly better than we've heard in a lot of other districts. But I want to ask you some questions about that. When you submit a request for expert services, you said that it's not just automatic, but can you tell us, like, percentage-wise, how often it's authorized for you? You personally, obviously.
Sure. When I say experts, I mean including investigators, interpreters,
Sure.
Psychologists. In the majority of my cases, I'm asking for, in probably 75% of my cases, I'm seeking funding for some kinds of experts. It might be even more these days. Lately, we have these multi-defendant drug cases that come in where we receive literally tens of thousands of pages of discovery and thousands more email files and audio files and Excel spreadsheets and line sheets from wiretaps. And those cases alone require us at this point to hire an expert. We have experts here that do electronic discovery for us, and we'll take our discovery, take those thousands and thousands and thousands of documents and files and put them into a searchable database that allows you to drill directly into, take the 36,000. There's one I actually spoke about in my comments. I had 36,000 documents to start with, and I was able to hire this expert and narrow it down to the 41 that pertain to my client. So I do hire an expert of some kind in almost every case.
And how often is it? I guess my question is more to the issue of the requests that you make, how often are they authorized? How often are they granted?
I have had one request in the 4 years that I've been on the panel. I have had one request denied.
So it's
I have had several occasions where either somebody from the CJA panel administrators section here at the FPD or Steve Wax himself called me a few times, or I've had judges call me where they've said, you haven't explained yourself enough. You're asking for money here, and we need more information in order for you to authorize this. So I feel very lucky in that I've never had a situation where I've felt that a client has not gotten the defense he or she deserved because we were not able to obtain funding.
So all those times that you just described, ultimately the funds were authorized, correct?
Yes,
All right.
ultimately funds were authorized.
Let me ask you this. You're obviously a CJA attorney, so you know how the process works. There's an $800 pre-authorization, so you can get started without the authorization, but it's $800 for all services, right? My question is, are you able in this district to just safely go forward and hire an expert before you actually receive the authorization from the court?
I do that. Normally, the $800 authorization is either not something that can be used for the kind of experts we need, or it's used very quickly. Sometimes we'll use those for interpreters. Polygraphs is another thing that sometimes is a low enough low enough threshold to do that. But yeah, I mean, I get these. I get these experts in just about every case, and I do some work before the funding comes in. Usually that's with investigators, because getting an investigator is something that, because of the nature of most of the cases we see here, that's something that does have to happen in almost every case.
It has to happen usually quickly, right? You
Usually
want to get
quickly.
started.
And our investigators that we use here know that they can move forward into these cases knowing that the funding is going to come in. And that is very much a boon for the practice because if you have to wait 2 or 3 weeks, because sometimes we put the funding request in and it can be 2 to 3 weeks or a month before we get the actual approval. And if our experts didn't know that funding was eventually going to come in and we have to wait for 3 weeks or a month to start on these cases and to start the investigation, that would very much hamstring us. Other experts, psychologists, I guess experts that I would call not run-of-the-mill, that are specific to a particular case, like a cultural expert, those I do wait until I know the funding is going to come in for a couple reasons. Number one, I don't just assume the funding is going to come in, particularly if it's an expert that I'm seeking that's not a typical kind of expert. But number two, those experts are often not always needed right away, and we have the time. I can see, okay, if I hire this expert now, if I seek the funding now, it'll come in about a month. That'll give the psychologist 2 or 3 months before our upcoming, the next court appearance to get something like that done. So it depends on the nature of the expert. But there are certainly times where we do move forward while the funding is pending, just because we are confident in this district that funding will come in.
Thank you. Mr. Needham, I also have a question for you, just to compare the two districts, or I guess this is the District of Oregon and the state of New York, the two different places that you worked, and the way in which you could represent a client in the Federal Defender's Office in Oregon versus the Legal Services Program in New York.
Well, as experienced defender in Manhattan, I had a caseload of almost 40 indictments. Here in the District of Oregon, I have about 25 to 30 indictments, but they're at various stages. The system in New York back in the 80s was so crowded that when the parties declared ready for trial, they had to wait 3 or 4 days until a trial court opened up, and there were over 80 Supreme Court trial level judges in Manhattan. So there was an expediter who went around to the various courtrooms and was trying to find a judge that didn't have a trial going. So here, of course, in federal court, when you have a date certain for trial, the court sets the trial date weeks in advance, and when you have a trial date, you go to trial. We had the ability to hire experts in state court, but the practice wasn't as sophisticated, didn't have the amount of the discovery that we here have in federal court. In our office here in the District of Oregon, in the Federal Defender's Office, we have a number of paralegals, investigators on staff that have expertise in various areas. Our paralegals are able to organize the large amount of discovery that we received from the government on disk and put it in a format and review it so that the attorneys can have easy access to it and see what's there, because private CJA counsel don't have that type of staff in their firm typically. When we have the lead defendant in a multi-defendant case, our office takes the lead and organizes the discovery materials and tries to work with the panel attorneys as best we can, understanding that there's potential conflicts, but so that we can organize the discovery materials and the panel attorneys can have access to it by coming to our office. And we try to work with our co-counsels to lessen the bill, so to speak, to the CJA attorneys. The same thing with our investigators. Our investigators have are on staff, have a level of our expertise that can look at evidence and decide what type of experts that we need to retain. It's just more of a sophisticated practice as time has gone by since New York City in the 1980s.
Thank you.
Mr. Frensley.
So, Judge Acosta, I wanted to ask you what has been described in the District of Oregon really is a great example of collaboration between sort of all the pieces of the criminal justice system, the three-legged stool, if you will, of the court, the U.S. Attorney's Office, and the defense bar. And I'm curious, just to the extent that you can inform us a little bit about how that sort of a culture of cooperation and understanding of things that may be more sophisticated than sort of just simply, law and order, black and white, that kind of thing, comes to exist, and how it's perpetuated within the District of Oregon. And just to make things a little more complicated, how that sort of culture could be replicated in other places.
Well, this is Oregon. We're all very nice here.
I saw something on television last night, actually, about people littering and the folks of Oregon getting onto them and picking up their trash and throwing it away for them.
That really does
I think
happen.
you're right.
Yeah, that's right. Let me answer the first question. What's different about, what contributes to that culture? By something my wife related to me when she attended the very first criminal calendar day I ever had as a judge. Of course, she was in the courtroom before I was, and so she was sitting in the gallery, and the assistant U.S. attorney and the assistant federal public defender were at the table ready for the judge to come out, as is the routine here. And she told me afterwards that she was surprised and impressed about how collegial she called the prosecutor and the defense lawyer were. And I hadn't really thought about it before, but I know it was my experience as a civil practice lawyer, and I'm a big advocate of professionalism as well, so I was pleased to hear that from her. But what I found in my time since then, over the years, is that one of the things that makes our system work well is that it is an adversarial process, but the relationship that exists between the U.S. Attorney's Office here and the Federal Public Defender's Office is, I think, quite unique, because the lawyers have strong opinions about things from time to time. There's no question about that. But people work together. And so when you have a situation where a defendant is in the CAPS program, there's a lot of collaboration. There's a lot, people recognize the common goal. Look, if someone can get a shorter sentence, if someone doesn't have to be incarcerated, if someone fill in the blank, there's a receptiveness to that notion on the prosecutor's side, and it is something the defense lawyer knows can be pursued and might well work. It won't be dismissed out of hand either by his or her opponent or by the judge. I have a case right now where the assistant U.S. attorney on the case is, I don't know how else to put it, working really hard to help this particular defendant show up at sentencing later this month as well positioned as possible to try to get probation. I don't know how else to say it. I mean, it's true. And I say this in all seriousness. There's just something about the people who live here, live in this district, live in this state, that contributes to that culture. How can you export it, if you will, to other districts? One way, I've heard this said by other lawyers when it comes to professionalism. Judges have to set the tone. It's on us. Are we the only ones in the process who can make that happen? No, everybody has to contribute. But if the judge models the behavior, models the notion, the concept, acknowledges it as something to be desired, something that he or she desires, that's a really good start.
Mr. McHenry, I wanted to ask you, you talked about the assistance that the Federal Defender's Office gives with respect to panel administration. And I'm wondering if you have ever had any concerns about potential conflicts that might arise out of the panel administration being conducted through the Defender's Office, And secondly, I guess I assume that the individuals that you work with in panel administration are not lawyers, or are they lawyers?
Some of them are lawyers. I know that. Personally, I've never had a concern about conflict over there because I know that the Federal Defender Office here does everything they can to screen off the folks that are working under the CJA administration. They don't have their own caseloads. They don't talk to or participate in staffings on cases that are going in the office for that reason very specifically. The panel administrators are, I know, as I said, at least some of them are attorneys and have been in the past, which certainly helps when you're talking to them about what works and what's available. I guess I would say the one concern I have, and it's not related to the CJA panel administration in the office, and also not related to any specific situation of mine. I want to make that clear, but there has always been a concern of mine about seeking approval for funding for experts from the same judge that's going to be ultimately either presiding over the trial or over the sentence. And again, our judges here have never given me an indication to think that that is a problem. But I can envision a situation where maybe I ask for some funding for an expert, a psychologist, for example. The judge approves that, and down the road, sentencing comes along, and I'm not presenting anything from that psychologist. I think that judge, just human nature would be looking askance as to why this funding was authorized when it doesn't look like that was used down the road. And perhaps subconsciously that may put a thumb on a scale at sentencing one way or the other. That's a concern I have, just from I guess from a procedural and theoretical perspective. I've never had that concern about talking to people in the Federal Defender Office about my CJA cases, because I've been given several assurances and I've seen the process over there. I've worked in that office. I know how they do things over there. They do it right.
Have you thought about, or would you have a recommendation if it wasn't the judge? In other words, if the judge wasn't the one who ultimately made the decision, yes or no, on that expert, who it would be or who it should be?
Well, I think it's right to have a judge looking at that, certainly at least at one level of approval. But I'm not sure it has to be the same judge that's presiding over the whole case.
And why do you think it's important that it be a judge?
Well, because I think those judges have the experience and the independence to be able to, they have the experience of seeing the kinds of requests for funding that comes in and knowing what the industry standard is, for lack of a better term, and also being independent enough that their decisions on these things are somewhat not beyond question, I shouldn't say, but the decisions they make in these cases, being independent, not being part of the defense, not being part of the prosecution, I think are, at least to the public's eyes or to other people, easier to stomach, because you don't have somebody making the decision that is biased. I think it wouldn't be right to have just people in the Federal Defender Office reviewing our funding requests. And certainly it wouldn't be right to have people in the U.S. Attorney's Office reviewing our funding requests. I think it has to be reviewed by somebody who has that's removed enough from the case to have that independence and not have a vested interest in the outcome of the case. And I think it should be a judge. I'm just not sure it needs to be the same judge that's presiding over the whole case.
I could answer that question about potential conflicts when the Federal Defender's Office reviews the CJA vouchers. Lisa Hay and the Chief Deputy, Steve Sadie, if they have conflict with it, they'll ask one of the other senior attorneys to review the vouchers and sign off or make suggestions or call the attorney, and they'll step away from it because of the potential conflict. Two panel administrators go through the vouchers, from what I understand, and just look for general accuracy, make sure that the court appearances that the attorney is claiming he or she appeared in court are reflected on the docket, and see that contact the experts, that see if they had actually been used. So they just do a kind of a two-level review, then they pass it over, from what I understand, to Ms. Hay or Steve Sadie, and then they review it. So there's 3 levels of review, I think, before it's forwarded to the district court judge.
Anything?
Mr. McHenry, I actually want to press you on your last, Mr. McHenry, I want to press you on your last answer that it should be a judge approving these expenses. And, you know, I'd put it to you that the U.S. Attorney's Office has a budget. They decide how they want to best spend their money representing their client, the United States of America, with that budget in mind. And no judge approves that. Why shouldn't we have somebody who is interested in the welfare of your client, but is also mindful of the total resources available to the system, who is not in any way a participant in the, you know, in the judicial system, in the action which you're a part of, approving your expenses?
Well, let me start by saying that I would feel much more comfortable submitting my funding requests if it was going to be approved and only looked at by someone in the Federal Defender Organization, just because, as you say, that they do have a vested interest in my client's outcome. The reason I think that it makes sense to continue to have an independent member of the judiciary at least reviewing the final decisions on this is because, frankly, funding for indigent defense is a political hot potato. And, well, I think it would be okay, and I believe that the people in the Federal Defender Office would carry out that role in an ethical and upstanding way. Not everybody in this country and not all of the public feels the same way about the defense bar as I do. And in order to, one of the things that over the last decade or so that I've seen more and more is more of the public getting on board with this more holistic approach to public defense and to criminal defense in general. And that's something that it's a political movement and kind of an uprising that I can very much get behind. And my personal view on that is if we want that to continue, we need to be as clear and transparent in what we do and the funding we ask for as possible. And I think that getting a member of the judiciary involved at the approval level for that reason is quite important because of the public perception of where this money comes from and what it's used for and who's asking for it and who's making those decisions.
My next question would be for actually Mr. Howard and Ms. Cleveland and Ms. Bell. And what I wanted to ask you about, you know, we're charged obviously with not with the entire criminal justice system, but only with the representation of clients and how best to further their interests. And so in trying to break out your stories, I'm trying to figure out what are the specific things that your lawyers did for you that most mattered to you in your cases. And if I can start with you, Mr. Howard, and talk to you about what you saw. And maybe since you had a few brushes with our system, you can tell me how what your lawyer did here really differed from what you'd seen in the past.
Okay, so basically, when I started dealing with the charges that were federal, that was the first time I'd ever dealt with the federal. Mostly everything that I had done was through the county. I was always in and out of county jail and whatnot. But the thing that I think that Steve did, and one of the things that you guys are talking about, investigators and people that have been hired to do things, I think that what Steve did was he had the investigator look into my family also to see if there was any trauma or anything like that, because that's what they're going to do. Why was I doing what I did? Why did I spend 36 years, just running around amok. Well, like I told you, my family I came from a really good family. I had no excuse. I mean, my childhood was great. I always say that. I just had the greatest childhood there ever was. My parents, my father was a minister, and my mother was, she raised five kids and three foster kids. I just happened to get into drugs and just went sideways. And I think what he did was he used the fact that I did have a good family. He used what was there, which meant that I had a lot of community support. I mean, I had a lot of family support, and that I wouldn't be a real burden on society if I didn't go to prison for 5 years. I mean, I wouldn't be a public safety. I think this is one of the things I think he explained to me, because I wasn't very happy about the fact that my family was brought into this, that my mother was interviewed. He didn't tell me he was going to do that. It was just, he told me afterwards, but he explained to me why he did it. I think that the number one thing that he helped me with was all of the suggestions that he made about doing things the right way, doing things that to help the community, that the community be aware of, because I ended up using all of that, all of the things he told me I needed to do. He says, you need to get yourself involved, and you need to go get cognitive, you need to attend AA meetings, you need to volunteer, things like that. And I think that was the biggest thing that he helped me with was, grow up, man, and he said that in no uncertain terms. And it was real easy for me to understand that at the age I was, I didn't want to be in prison, man, any longer. I went to prison at 54. I did my crime. I got arrested at 52. And so I think the biggest thing that I got from him was the support. And, I've talked to Steve recently. He's one of the people, and I think the panelists here will tell you that you're going to meet people in your life that you're never going to forget. You're going to meet people in your life that made a difference, and he's one of them. He's the person that every chance I get, I always mention something about Steve and his office. I mean, the whole office was very supportive of me doing the right thing, and that really helped.
Can you give me any idea, and I know this was a little while ago, so it's hard, but any idea of how many hours you think Steve spent with you over the course of your case from beginning to end?
Okay, so, I would say, let me think how many times I actually met with him, because I think that, I can't remember the gentleman, the judge down here, I remember he made me think about something when he said that he would invite his clients into his chambers. Well, that's one of the things that Steve would, come up and see me, and I'd be in his office, and sitting there, and it was always helpful because he was calm, and he was really calm, and I'm looking at, going to prison, but he kept me even just by his calmness and talking to me. But, if I look at it and think how many hours he spent with me, I would have to say during the course of my, once I got out of jail, I was sanctioned or actually sent to jail after I didn't act right on pretrial. I think that probably 20 hours he may have, I may have, just showed up in his office, or I called him on the phone. I was pretty worried. I'd say 20 hours over the course of, from the time, which was 2000, like I said, February the 2nd, 2006, until I actually got off paper. I was talking to him, and I got off paper. You have a better grasp. I didn't even know I was off paper. I called my PO up to ask her. I missed calling in for a UA, and I called her up. And I said, Sarah, tell me I didn't miss my color. And she says, oh, Felton, I'm sorry. You've been off probation for 3 weeks. So I didn't even know. And so I was on my way to work. But I think in between that whole time, from the time I actually first met him, and I was in the lockup in this building upstairs in the jail, I think I was waiting for my first arraignment until the time I got off paper, probably 20 hours. And I don't know if that's a lot of time. I don't know if that's, but for me it was enough,
Ms. Cleveland, I'd actually like to ask you that same question. Can you give me any idea how much time you think you spent with Mr. Needham over the duration of your case?
Oh my goodness, I'd never even really thought about how much time. Phone calls and conversations and visits to the office and idea.
Can you give me a guess, Mr. Needham?
I would say in excess of 40 hours. Yeah, we keep timesheets and we could.
Yeah,
supply
no,
the
I
information
know.
at
I'm
some
just
point.
asking you to, spitball it for me. So 40
sorry?
hours. I was just asking you to spitball it for me.
Yeah, no,
40 hours.
I would
seems
say
reasonable.
40 hours or something along those lines.
How about you, Miss Bell? What do you think about
I'd
your-
probably say about 50. He came to jail and visited me quite regularly. We went to lunch a few times. We met at his office. We met at the Union Gospel Mission, had meetings there. He took me out on several outings, we went to Multnomah Falls and met out there once. Yeah, I'd say about 50 hours. We spent a lot of time together going over my case and what was going to happen next, what was the next step, because like I said before, I really didn't know what was going on. And so we also emailed each other. There was phone calls. When I was in jail, he'd send the private investigator up there also. If he couldn't meet with me, he also sent the private investigator to my hometown to go over the setting of the house and how things were and to ask me questions. So that was about 50 hours.
Can I ask a follow-up question? Okay, so I want to ask a follow-up question to Mr. McHenry, Mr. Needham, and to you, Judge Acosta, on that same topic, but from a different angle. I believe tomorrow we're going to have various testimonials about, and we have heard from other locations, problems with people that are incarcerated, remote location, trying to get to see their clients, being able to spend time with their clients, attending to their clients when you have to travel 3 or 4 hours just to see them and then get back. And all of these wonderful programs that you're talking about, that when someone's incarcerated, it isn't happening. So for you, Mr. Needham, and you, Mr. McHenry, could you tell the committee the difference between representing somebody that you have that kind of access as you're talking about too, and you can work with on a daily basis, versus someone who's incarcerated and you can't? How that representation is different is my first question. And then also how Mr. McHenry, particularly probably for you, how if you have to travel like that, how the billing is dealt with, if you have any problems with that billing. And then for you, Judge Acosta, how is it different in the courtroom dealing with those defendants who haven't had the opportunity to have the CAPS program? So I guess we'll start with you, Mr. Needham.
In this district, the Marshal Service generally houses clients at 3 locations. One in Multnomah County Jail here in Portland. They have 2 locations. One is right across from the street from the courthouse, and then there's another about 30 minutes, 15, 20 minutes from our office that we have to drive to. But because of the cost in Multnomah County, from what I understand it costs $120 a night that Multnomah County charges the Marshal Service. The vast majority of our clients that are detained are held at the Federal Detention Center down in Sheridan, which is about an hour and a half each way. They also house some of our clients up in Columbia County Jail, which is about an hour each way. So when we want to visit our clients down in Sheridan, we have to email the facility. Usually the turnaround is within 24 hours. They email us back and say that they can fit us in on a certain date and time. Typically the lawyers on our office try to schedule 2 or 3 clients on a visit just to take advantage of the travel time. I guess it's been maybe 10, 12 years ago that we used to have a video hookup from the courthouse that was secure to the facility in Sheridan so that the lawyer could talk to his client through the video conferencing. The machine broke down numerous occasions, and there's never been funding to hook that up or have new video conferencing. The United States Probation Office has a video hookup from their office down to Sheridan. We are able to piggyback their machinery, and when they're not using it, they allow us to use it. It's not the ideal because they use it for their own purposes. It would be nice if the court was to spring, so to speak, to have that video conferencing that was in this building directly at facility. That would certainly save time and money, in meeting with the clients. Columbia County is a very nice facility. The staff is very accommodating of us. Their phone system is rather poor. There's just low quality, and the clients don't always have the ability to get in and make the phone call. So that's troubling. But they work with us, and we have one contact room up there. On many occasions, they allow us to use the Sally Port, where there's another room where they lock us in with our client. It's not ideal, but at least we can get a contact visit with our clients. Again, we have to call Columbia County and schedule that visit. So those are some of the things that we encounter. But you're absolutely correct. When our client is detained, it's much more difficult to have contact with them. We have to arrange the visit, and we have to look at our calendar. The local jails in Multnomah County have a nice feature where we're allowed to call in and speak to our client at certain hours of the day because we have an access code as an attorney. We can't do that at Sheridan or at the Columbia County Jail. The clients can call on secure lines and speak with us, call collect from both those facilities.
Well, I guess another part of my question is, do you see these kinds of successes? Are you able to give, the kinds of support that you're able to give these kinds of clients to those that are remotely detained?
No. We're just, obviously, we can't have a CAPS hearing once a week with a client that is detained, or the clients can't come to our office if they're detained. So it's much more difficult. It's much more of a challenging representation. You have to bring the discovery to the facility. Some discovery materials have protective orders, so we're not allowed to mail them to our clients. We have to work with the Bureau of Prisons if we want to bring a laptop computer in, which has the discovery materials on it so that we can review it with our clients. It's particularly challenging when there's a protective order. The government typically allows us, the attorneys and our investigators and our expert, to review unredacted materials, but they do not want the materials furnished to the client who's in custody because it's not secure. So that's another burden that is placed on us. Our investigators have to travel numerous times because the discovery is quite large in many cases. So yes, that's a challenge.
All right, Mr. McHenry?
Yeah, echoing what Jerry said, it's representing clients that are in custody is a challenge. There's no question about that. One of the things in this district that I think is wonderful about working here is that we have an excellent pretrial services release office, and we have magistrate judges that let clients out and give them chances to show that they can succeed out of custody. And certainly some of the cases that I've been discussing today, the resources that are available are much more readily available to folks that are out of custody. Setting yourself up to engage with the Women's Resource Center, for example, obviously wouldn't have been available to somebody sitting in custody. Now, that being said, we still do our very best, and I know Jerry's office does as well, to give that same level of representation to our folks that are in custody. But it is much more difficult. The logistics alone of trying to get out to visit a client at Sheridan, for example, that's an hour and a half away, is hard enough for me. I have to email somebody to make that happen. I have to work it into my schedule. I have to wait for a response to see if they can work it into their schedule. If they already have X number of contact visits going on that day, they can't accommodate it. And that gets nightmarish sometimes when we're trying to get an expert out there as well. I want a psychologist to go out and do an in-custody evaluation of my client. So it's certainly much more difficult in those cases where the clients are given the benefit of pretrial release, or at least a shot at pretrial release. just because of the nature of how things work, they often get a better outcome at the end. Now, that being said, if a client is held in custody at the beginning of a case, there's always reasons for that, and perhaps there are other factors coming into play that make that client's outcome less desirable than it would have been otherwise. But we still provide the same level of service as we can. I'm thinking of a client that I have in particular right now who's doing a 36-month sentence in Edgefield, South Carolina, who would come here today to tell you, if he could, that were it not for a psychological report that was done by Dr. Megan McNeil in custody, he'd be doing a 70-month sentence, and he is overjoyed to be at Edgefield for the 36 months that he's doing there. So we don't just, we still try to make those things happen. In terms of the billing and how that works, it's frustrating. We, as CJA panel attorneys, I know we try to do the same thing that Jerry's office does, and I will try to schedule 2 or 3 clients at Sheridan if I know I'm driving out there to make sure and bill the outbound trip to one client and the return trip to another client. That's not always easy to do. In addition to the facilities that Jerry mentioned, there's a facility in the Dalles that I often have clients at called Norcor, which is another hour and 20 minutes the other direction, up the gorge. And the problem is the phone systems. Well, it's ironic that the best phone system we have, that I can just pick up the phone and call a client on a secure line that's not monitored, is here in Multnomah County, where I can also just walk across the street and go visit them. The ones where we really need to be able to pick up the phone and call, Sheridan, Columbia County, Norcor, we can't do that. I'm told often, depending on who you call at Sheridan, sometimes I'm told, well, you have to send your client a letter and ask them to place a phone call to you. Sometimes they'll say, well, we can give the client a message to call you back. And sometimes that works, sometimes it doesn't. When it does work, they're often calling back, collect, on an unsecured line that's monitored. And they say, I can't talk to you. And I say, of course you can't talk to me about this right now. This is a monitored line. So it's very difficult, because there are often times where I need to speak to my client quickly about something that came up. And I can't get a phone call in, and they're an hour and a half away, and I have to schedule a meeting with them first. So it presents quite a challenge in this district. Certainly if our clients were housed closer to us, it would make communication a lot easier, and it would also cut our billing, I think, significantly. I mean, that's just the nature of the practice as well here. We often have these multi-defendant cases where, due to conflicts and keep separate orders, where certain defendants can't be housed with other defendants, we have no choice but to not have somebody here locally because of other inmates that are there. And I'm not sure what the answer is there, but the response to the question is it is very, very challenging to visit these in-custody clients.
Excuse me, Your Honor. Ms. Cleveland has to leave. Her ride's going to take her back to Washington.
Okay.
She's 2 hours away from
Okay,
Portland.
thank you so much. Thank you.
I'd just like to close the loop on the question I asked before, and I don't want to keep you, Ms. Cleveland, but if I can just ask all 3 of you, without the hours that you spent with your lawyers, do you think you would have gotten the same results out of this process?
No.
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 Okay, I expected that, but for the record, we needed to close the loop. Thank you. Good luck.
Mr. McHenry, do you have any problems getting paid on those remote? No.
No. I have never had that experience. I know that attorneys in other districts occasionally run into that. I don't think that's been a big issue in this district. I also know that myself and the other panel attorneys that are required to keep time are pretty meticulous about the time we keep and do our very best to explain everything. And I also know, at least in my own practice, that there's a lot of time that doesn't get billed, that we don't put into vouchers. For various reasons. For example, a phone call, I can think of one client whose mother called me every day. And I picked up the phone and I answered that call and I spoke to that woman every chance that I had when I was in the office, I didn't feel comfortable billing CJA time for having essentially calming down conversations with mom every day. I billed for maybe 10% of those phone calls. I think it's important to stay in touch with clients' families, and often a lot of the mitigation investigations that we do require us to speak to clients' families. But I always have an eye towards things like that, and making sure that the time I submit, and I'm not alone, I know that all my colleagues on the panel do this as well, is justified and is something where I don't want to ever be putting the people reviewing my vouchers into a situation where they're raising an eyebrow and wondering, if this is justified. So we are very meticulous about the time we keep. We don't bill a lot of time. There are times I put in my voucher, I'll put in a task and just put 0 hours, just because I want the courts to know that this work is being done. I want the court to know that the work is important, but that I don't always have to be paid for every 0.1 hour I spend on everything. I do a lot of texting with clients that are out of custody. We do a lot of emailing with clients. Those are very difficult to keep track of in terms of time. So I'm always erring on the side of caution and being conservative in those kinds of situations. And because of those practices and the understanding I think that we have in this district about the quality of the representation, I personally have never had a voucher cut, with the exception of one time where Steve Wax cut a voucher of mine. Because I had a client who had a pending state court case as well. It was a very, very sensitive situation. I was not comfortable sending my client out to deal with this state court situation with a court-appointed attorney out there who wouldn't know the history and background and the sensitivity of the situation. So I represented the client at that hearing. I billed for my travel time out there. And Mr. Wax told me that I couldn't do that. And I accepted that. But that was in 4 years of practice. That's the only time I've had a voucher cut. And I understood why.
Judge, do you see a difference in the clients that are incarcerated and outcomes, et cetera, and the way their attorneys are able to represent them versus ones that are not?
Yes is the answer, but I have to qualify that by reiterating what I mentioned in my written submission, which is, in this district, we don't deal with criminal cases beyond the initial appearances and the detention hearings, with the exception of someone who's been released and may come back on a pretrial release violation. And so let me speak to the experience that I have had on the bench. One of the things that often is important to a release decision or detention decision is an assessment. Someone comes before us, they have an addiction history, they have a current addiction, they have other issues. There could be cognitive issues, there could be mental health issues, and I can't make a decision whether the person should and be released and can comply with conditions unless I know more about their ability to understand the conditions and more about their ability to comply, and that often requires an assessment. If the person's taken out to Sheridan, if the person's taken up to Columbia County, if they're any place other than directly across the street, it makes the assessment process more difficult and more time-consuming. So they're detained longer than they should be. Here's the other thing. Someone who's detained doesn't have the opportunity to take advantage of the treatment services that can be obtained through pretrial services while you're awaiting the resolution of your case. They're in detention. They don't have a choice but to, for all intents and purposes, be sober. So that when they get out, the first thing they might think to do is, I'm going to go score drugs. That's what I'm going to go do. And unless they're close by, unless I can have them initially assessed, unless their lawyer can get that assessment quickly and advocate as appropriate for the release, it's actually to the defendant's disadvantage, because if they do happen to get out later on down the road, they don't have any place to start. They've had no experience trying strategies to stay sober, to get treatment, to participate in group therapy, to find a job, to do all the other things they can do. If they're closer by, we can get it figured out more quickly, and they can start working the resources that are there.
Judge Fischer, do you have any follow-up? Chip, any follow-up?
Maybe it's beating a dead horse, and it may not be fair to ask this question, Mr. McHenry, but do you think that if instead of having your vouchers approved or your request for experts approved almost every time, that instead you had your request for experts denied every time, and there were times when you went ahead and spent the $800 only to have the judge tell you, well, I'm not even going to compensate that. Now that $800 has to come out of your pocket, even though you weren't required to ask me before you spent it. Do you think that would have any impact on your position about judges being the one who are ultimately deciding that issue?
Yes. As I hope I've made clear throughout my testimony today, we have wonderful judges here in Oregon and it's not just because they approve our request for funding. It's because they also understand the importance of the whole client approach. And absolutely, if all of my requests for funding, or even a lot of my requests for fundings, were rejected, that would cast a shadow on these representations. I can speak to clients now and tell them, we can get you evaluated. We can figure out what's going on in your head. We can get to the bottom of this drug addiction issue we have. We have the resources to do that. And that, the confidence that I can speak with to clients about that instills confidence in them and their own confidence in me and the justice system. And if I have to go in there and say, boy, you really look like, it seems like you could use an evaluation here of some kind. It could be really helpful, and maybe I can get the funding, and if we can't, sorry, we'll just have to go forward without it. I mean, that breaks down the representation on so many levels, just in terms of the interpersonal relationships we have with our clients, let alone the confidence the client has that they're getting the best defense out of the system going forward that they can get. So I guess that's a long-winded way of saying, yes, it would very much affect the way we do things around here if we were getting if we weren't getting approved for our funding, and certainly if we weren't getting even reimbursed for the $800 threshold we have.
How is it that, and this just may seem just sort of like a goofy question to you, but how is it that panel lawyers even know that that's the level of practice that they should be using? Is there training that the defender's office does? Is it something the court does?
There is training. Our federal defender office, boy, it seems like every couple weeks we have a CLE over at the federal defender's office that the vast majority of panel attorneys attend, and most of the federal defender, assistant federal defenders themselves attend. We have a very collegial community here among the CJA panel attorneys. I learned to practice law from my mentor and partner, a guy named Mike Levine, who was a federal defender for the District of Hawaii before he came over here and was an assistant federal defender in this office. There are more distinguished, I won't say older, our more experienced members of the CJA panel are very, very willing to share their experiences, to talk to younger members of the panel. And that's how I learned to do it. I learned to do it from talking to panel attorneys that had been doing this kind of work for years. I learned to do it by talking with assistant federal defenders in the federal defender office. These people are all very, very busy, but everyone seems to have the time for a fellow member of the defense bar that wants to figure out how to do things right. And yes, we have these trainings. I mean, every time I go to a training, we'll sit there for an hour, and sometimes I might get 2 minutes worth of things that are good. Sometimes it might be a full hour of things that are worthwhile. But I never walk out of these trainings thinking, boy, I wish I hadn't gone to that, because there's always something new that we can use in there. And then it's the camaraderie, because you're bringing everybody in for these panels and these trainings. And you see your colleagues that are on the panel, and the trainings sort of trigger these conversations amongst ourselves about what works and what doesn't. And, oh, have you tried this expert yet? And this, this psychologist did a great job for me in this particular case. And it's a matter of, it's a combination of things, but certainly training in our collegiality, I think, is a big part of it here.
I forget, and I apologize, whether you also have a private practice. And do you see a difference between what you're able to get for your panel clients, because the judges are so willing to do this, and what you're able to get for your private clients because maybe they don't have the several thousands of dollars to hire one of these experts?
I do. I've seen that in more than one situation. At times you're better defended by being indigent, at least in the federal system here. That's certainly not the case at the state level here. But we've also had situations where I've had privately retained clients who can't afford an expert, and we ask for a CJA appointment, at that point or midway through the representation. What I really see in practice is, in private practice with privately retained clients, when you tell them they need an expert for something, but they'll have to pay for it, then they start to question very closely about how important it is to have this expert, and questioning my assessment of whether the expert's really necessary. If it's a court-appointed case, I don't get those questions because there's not a concern about the pocketbook so much. So it is a little ironic in that sense.
Judge Acosta, do you see that kind of difference in the kinds of things you do? Do they not know to advocate for the program, perhaps?
It's an interesting question to me because we're not as involved as deeply in this part of the process as magistrate judges in other districts. But let me share what my experience has been on the bench. I graduated from law school in 1982 and went to a large law firm. And as a new associate, being in a large law firm with lots of resources, you kind of take for granted the opportunities you get. Everything is done for you. Everything is paid for. You're representing clients where, by and large, resources are not an issue. And we had a joke as young, inexperienced, and perhaps somewhat naive and arrogant young lawyers. We used to say, you got bucks, you got rights. And man, it's true. I came to the bench and I didn't really appreciate how true that was until I sat up there and saw the disparity of resources between one side and another and what a difference it makes in your ability to represent your client. And that's on the civil side. On the civil side, almost always the only thing that's at issue is money. Really, that's it. On the criminal side, man, it's a lot different. It is a lot different. And the things that Matthew just described, I mean, the difference between a client questioning you closely about whether you really need to have fill-in-the-blank kind of expert to defend himself or herself when they have to pay for it, compared to knowing that in the professional's judgment, if an expert is needed to address a critical issue in the case, it will happen. That's the way to be able to be able to practice. It doesn't mean you get a blank check and you get to hire everything and all this stuff, but you need to be able to bring to bear the resources that to approximate those the other side possesses. Because if you can't do that, you are at a disadvantage right from the get-go.
Catherine, do you have any follow-up?
Just a few things. Judge Acosta, I wanted to ask you about the CAPS program. It sounds like the program is kind of like a supersized pretrial services. And so I'm wondering whether you received any pushback from the pretrial services office when you decided that you wanted to be directly involved in supervising the folks who would normally be the folks they supervise.
You bet. Not from the pretrial services office. If I did get pushback, I learned of it indirectly and on one occasion directly from the U.S. Attorney's Office. So let me explain that because I don't want to leave that just there. And let me start with pretrial services. although in the very first time I ever suggested taking this approach, the pretrial services officer had doubts simply because it wasn't anything anybody had ever done, at least any judge had done before. What I found, and there are some pretrial services officers here in attendance right now, is that the pretrial services officers were receptive to the concept because the role of the judge is to support the officer's supervision. I tell defendants, I am not, the pretrial services officer is responsible for your pretrial supervision. They are the ones that you answer to. I am here to support you in this process. And when the pretrial services officer speaks, the pretrial services officer speaks with the authority of the court, and you need to remember that. And I am not a micromanager. I don't do that sort of thing. But if the pretrial officer needs something, he or she will come and talk to me about it. We share ideas and we strategize. So I think it's a very collaborative process. And I've had pretrial services officers on a number of occasions suggest to me that a particular defendant be released, but suggest they also participate in the CAPS program because they think that would help this individual. On the U.S. Attorney's side, there have been some occasions when I think the U.S. attorneys would rather be spending their time on their caseload than sitting in court or in my chambers participating in the CAPS process. Is that all the time or most of the time? No. Is it some of the time? Sure. Some of the time, I think that's what they feel, because they're there because it's an official proceeding in the case and they're representing the government's interests. And there was one time when I had a discussion about the effectiveness of the CAPS program and and whether what we were doing wasn't really more like social work than like some sort of legal process. And my response to that is, yeah, that's great, that's your opinion, but I'm going to keep doing it because I've seen that it works for a lot of the people who come before me. And Jerry said it doesn't work for everybody. Some people still go and they serve sentences, but they're better off when they come out because they know they're not just trying to get over the next UA. They're not just trying to get over the next court hearing. They know they have something coming out to build on, and that's what's key. And the pretrial services officers are critical, absolutely critical to that process.
Thank you.
So I'd have a question for Mr. Needham, Judge Acosta, and Mr. McHenry. And it's, the districts I've practiced in are very, very different from Oregon. I practiced in Miami, where the U.S. Attorney's Office was fond of indicting criminal defense attorneys, and San Diego, where I imagine if I described the way in which things take place here, my judges would tell me we aren't Sweden. So, and you've talked a lot about culture, and culture is notoriously hard to replicate and almost impossible to export. So the question to you with that premise is, can you talk a little bit about what aspects of the way you do things here you think we could replicate in districts with very different cultures and begin to maybe move the Overton window a little bit in those cultures, to begin to nudge them in a different direction? Can I start with you, Judge Acosta?
I said a little earlier, I think it starts with judges, and I think that is still true. The judge has to be interested in non-traditional processes, non-traditional approaches, be open to, in a particular case, trying something that hasn't been tried before. And knowing that it could work, but it also could not work. And I think if the judge takes the lead in showing an interest in the approach, the lawyers, even if grudgingly, will follow along. And let's face it, the lawyers don't have to like each other, but if they can work together in a professional way, the process can work. And it requires the court, pretrial services, the U.S. Attorney's Office, and the Public Defender's Office to all participate in the overall approach. Otherwise, it can't work. you know, we're very lucky in this district. You mentioned, you know, your experience in Miami. We don't do that here. I mean, every other word out of a lawyer's mouth in this district is not sanctions. It's not. And sanctions are a serious deal in this district, and so are the kinds of things that you described. And I don't know what to tell you with respect to how to export, if you will, a culture to another district, so that something like the CAPS program, for example, or the collegiality that the U.S. Attorney's Office and the Federal Public Defender's Office seem to share and have historically shared. I don't know what to tell you about that, but I do believe, I really do believe, that if you're going to have a chance at making it stick, it's got to start with the judge. And the judge, and to start with the judge has to know that this is something that can make a difference and a better use of the resources than endless motions to suppress or all the other kinds of procedural mechanisms lawyers are fond of using, including motions to disqualify and everything else.
Mr. Needham, do you have any thoughts?
Well, I think Judge Acosta hit the nail on the head. The judges in this district wouldn't put up with it. They expect the attorneys to act as professionals and deal with discovery issues in an informal basis. We have a standing order to get discovery within 14 days. Many of the government attorneys get that to us earlier than that. If there's an issue, we try to work it out. Sure, we file specific motions and we have arguments about that, but that's maybe the last resort after we've spoken to our colleagues across the street and they've given us the information and we've exchanged emails and letters. But the court expects us to act as professionals and deal with that. If there is a conflict, personalities between various folks, the heads of the offices meet and discuss ways to resolve it. But that's just the way it's been by the court in this district for the last 20 years and longer. I guess it's a culture that's been evolving since Mr. Wax was appointed the first defender in this district, I guess 31 years ago.
If I could, I'm sorry to interrupt, if I could just interject, because something occurred to me based on this discussion in further response to Ms. Rowe's question to me about pushback from the pretrial services officer. In a CAPS case, many times, often, the pretrial services officer, when we meet before the hearing, will ask me to reinforce a particular message, concept, notion, expectation, or to hold the defendant, quote, accountable, close quote, for something that's happened that we need to talk about. It's helping the pretrial services officer supervise the more difficult cases, the closer calls. It's a team approach to that, but the pretrial services officer is in charge and calls the shots on supervision. And that's, I think, one of the reasons that it works well and we don't get that friction that you asked about. Sorry.
I know we've got our other panel members.
All right. Judge, do you have any questions you'd like to ask?
I really have a question. I would have an observation. I see the whole client approach that we've been talking about as the result of a whole system approach. I mean, it really is. It's Chip referred to it as the three-legged stool. I would suggest it's a four-legged stool. It's the U.S. Attorney's Office working with dedicated defense lawyers and a judiciary that is committed to the Sixth Amendment, but it also includes pretrial and probation staff to carry out and execute what you've set forth. And so I'm trying to figure out how that's going to translate to recommendations, but I found this session very, very helpful as far as what we can take and move forward with. And probably the only other observation, before I was this judge-lawyer thing, I was a old probation officer. And so when I hear Ms. Bell and Mr. Howard and Jennifer Cleveland say that, whether it be Jerry or Steve, talk about they helped me help myself, that tells me you get it, okay? And that the whole system gets it. And I would just encourage you and Mr. Howard, you're already doing it, pass that forward. Okay, carry it out and pass it forward. But I don't have any specific questions.
Dr. Rucker?
Thank you, Judge Cardone. I'd like to ask a question primarily, I guess, of Mr. McHenry and maybe secondarily Mr. Needham about expert service providers. One of the things that we've been concerned with is equality between the defense and DOJ. Do you have any issues here with getting the quality of experts that you need and at the hourly rates that you can afford and be approved by the court in comparison to what DOJ may be paying?
I don't know what DOJ pays. I know that we have the experts that we use in this district. It's often, there are times when, I certainly have investigators that I prefer and psychologists that I prefer, and there are times when in a multi-defendant case, I will ask my psychologist to take on my preferred psychologist to do an evaluation, and they can't because they're doing an evaluation for somebody else in that case. So that does come up occasionally, but in large part, we don't have problems getting experts here because the experts that we use here, again, I hate to beat the dead horse, I guess, but they get this whole client approach too. And they aren't in this line of work simply for the money. We have the experts that I use routinely are charging me and the CJA half of the hourly rate that they normally charge because they see the importance of the work. So I don't know how that compares to what DOJ gets and what they spend. What I know is the experts that we get here are outstanding. And I have never had one say to me, I can't take that case because it doesn't pay enough. What I've had them say to me is, I want to help you out, and to help you out, I'll cut my rate in half so the CJA will cover me.
So are you negotiating with them on rates, or are they?
Yes, we do negotiate with them on rates because we do this with an eye towards the budget. We as panel attorneys know that the pool of funds are not bottomless, and we often negotiate rates with investigators and psychologists, and there are some experts that aren't willing to budge. Interpreters often just charge a flat rate, but most of the experts that I use are quite willing to cut their rates in order to get into a CJA case because they're also interesting cases. It's most of our federal cases where I'm trying to get a psychologist or an investigator are fun to work if you're into that kind of thing, right? So they're not just in it for the money. They're willing to take less money to do the job because they get to work with this particular client or they get to work on this particular issue that is something that's very important to them. Does that answer your question?
Yes, it does. Thank you. Mr. Needham, do you have any comments?
Yes. We keep a database of all the experts that the office uses. And CJA panel attorneys and private attorneys typically email our office or call our office for recommendations of experts. We put the comments the feedback we get from the CJA panel attorney as well as the attorneys in our office and anyone else that comments about an expert. So we have that information to share with other attorneys. And when the sequester hit, most of the experts agreed to take I believe it was a 10% reduction in their hourly rate. And Mr. Wax told everyone that they were getting a 10% across the board reduction, and there was really no pushback at all. They're all professionals and enjoy doing this type of work.
Thank you.
Ask?
Sure.
Judge Acosta, I just wanted to ask one question of you, and that is, what extent, if any, do you believe that the role of the Federal Defender's Office in the administration of the panel in this district has on the confidence that the court has in the actions and activities of the panel attorneys?
has a lot to do with that. I think the starting place is the regard with which the court holds the Federal Public Defender's Office in this district. So that's the first piece that has to be in place. Second, now this is just my, from the cheap seat sort of guesswork, but the Federal Public Defender's Office in this district has a really good reputation. They want to make sure that reputation continues. And the CJA panel lawyers that they vet and that we ultimately consider, that's part of that. I will tell you that in the time I've been on the bench, the lawyers I've seen in my court representing defendants, whether they're from the Public Defender's Office or a CJA panel lawyer, are consistently good lawyers who work hard and treat their clients like people, not just like this is a case file of a pile of case files I have and I have to get to the next one. And that makes a difference from the bench as well, because we can have confidence in what the lawyers, including the CJA panel lawyers, tell us when we are trying to make decisions like detention or release, the type of conditions, the representations those lawyers make to us about the communications they've had with family, prospective employers, ministers, other stakeholders in their particular client circumstances when they're advocating a release plan. So it has a lot to do with how the court views the CJA panel lawyers.
Professor Gould, do you have any questions? All right. Before we wrap up for the day, is there anything that any of you would like to tell us that we didn't ask you, that, to just make sure that we're aware of? Anybody?
Well, just to follow up on the training for the CJA panel attorneys, we do have CLEs once a month in our office, and sometimes we have experts from outside the office or other notable attorneys give presentations. We have a new group of attorneys going to be on the CJA panel, and they're going through training in our office. We also have a mentor program with the the new CJA attorneys. We pair them up with a experienced CJA panel attorney or another lawyer in our office.
So I would just say one final thing. Something that I would not have said 8 years ago before I came to the bench, and that's this. There's a special place in heaven for federal public defenders and CJA panel lawyers, and I would never have thought to say that before I came to the bench. And I would hate to see those people leave that practice because they can't get resources they need to represent their clients the way they think to do it.
Well, on behalf of the committee, thank all of you, particularly the clients that were willing to come here and tell us their personal stories, because although, as we all know, we're all in this together, you are willing to come here and be very vulnerable, and so we very much appreciate that. Thank you so much.